Chair thanks the gentleman and recognizes the gentleman from Virginia, Mr. Scott, for 5 minutes.
Thank you, Mr. Chairman, and Director Mueller, thank you for your very distinguished service. As you know, people acquiring firearms can, with a gun show loophole and a lot of other exceptions, easily obtain a firearm without a criminal background check. What difference would a universal or virtually universal background check make?
Well, at the outset, it would mean fewer persons who have the characteristics, debilitating characteristics, would be in possession of guns.
On the issue of these telephone records, you've indicated how the acquisition of all telephone records helps to protect us from terrorism. Is it true that this data can be used for things other than terrorism?
No.
You can't use it for criminal investigation?
No.
You can't use it if the purpose of the Section 104 wiretap is a significant purpose, the terrorism is a significant purpose, there may be some other purpose?
I'm sorry, I missed the question, sir.
Under Section 104, you can get the warrant. You have to show that a significant purpose of the surveillance is to obtain foreign intelligence information. Significant purpose was a change in the law from the purpose, which suggests that it's the primary purpose. If it's just a significant purpose, that would leave open the idea that there is another purpose for getting the information. When I asked Attorney General Gonzalez that question, what other purpose you could be using these warrants for, he blurted out criminal investigation, of course, without the normal probable cause and everything else. Is the acquisition of this information, this megadata, solely for protection against terrorism, or can it be used for something else?
Terrorism.
Now, if you tripped over some other things, like you noticed a crime, could you use it in a criminal prosecution?
No. Not that I'm aware of. The strictures are that you cannot. Now, there may be a way to go to the court if there was an egregious crime that you get some permission from the court, but the court would have to authorize it.
The exclusionary rule works because you don't illegally obtain evidence, because if you got it, you can't use it. There is a suspicion that some of us have that you're getting this information and you can use it if you've got one of these task forces and one of the guys can get a FISA warrant, the other guy can't. Well, you go get the FISA warrant and we'll track down, because you've got one of the guys in the place as an agent of a foreign government, so we can go listen in and see if we can't trip over a crime, then use the evidence. You're saying you can't use it for anything other than terrorism?
You cannot. The statute, if you're talking about 215, says reasonable articulable suspicion that a particular telephone number was associated with al-Qaeda or a foreign power. It's very simple.
And, yeah, significant purpose, not
Yes.
primary purpose.
I'm uncertain on. I'd have to go back and.
We changed it from primary purpose to significant purpose, which just opened up the idea that which just opens up the idea that you could have some ulterior motive.
Well, on that particular language and language change, if you allow me to get back to you, I'd like to give some thought to that.
And so that this information that we're getting can only be used for terrorism. That's what we're hearing.
Yes, under 215, yes.
In the IRS situation, there's some question as to whether some progressive groups were also targeted for scrutiny under Section 501c4 abuse. But if it can be shown that only groups targeted were targeted because of political views, would that violate criminal law?
I'd have to, that's speculative. Excuse me just 1 second, if I could. I just wanted to check where I was right on. I want to check my answers on my previous, on your previous questions. Thank you.
Okay. On the Boston bombing, obviously there was a little information. There was information out there that you could have used. Does do your limited resources limit your ability to track down each and every lead that you're given and compromise your ability to protect us against terrorism?
We get thousands upon thousands of terrorism leads each year. The Boston office is up in that range of those number of 1,000 a year. In this particular case, though, I do believe that when we got the lead on Tamerlan from the Russians, that the agent did an excellent job in investigating, utilizing the tools that are available to him in that kind of investigation. As I think you're aware, he did all the records checks. He went out to the interviewed persons at the college where Tamerlan was there for a period of time. Ultimately interviewed the parents, interviewed the Tamerlan himself, sent the information back to Russia, and on 3 separate occasions we asked the Russians for additional information that might give us indications or evidence that he was a terrorist. So I think we did a thorough job in following that lead. And at that point in time, I do not know that there was much else that could be done within the statutes, within the Constitution, to further investigate him.
Thank you, Mr. Chairman.
The chair recognizes the gentleman from Ohio, Mr. Shabbat, for 5 minutes.
Thank you, Mr. Chairman. And Mr. Director, as Mr. Sensenbrenner did, I'd want to thank you for your service over the years to our country. I also want to disclose that I happen to represent Cincinnati, Ohio, where some of the allegations, apparently rogue employees who were allegedly acting on their own were originated. But my questions, let me begin with this. The IRS, of course, is privy to some of our citizens' most sensitive information, and it's tasked with applying the law in a fair and impartial way. You would agree with that?
Yes.
Okay. However, the members of a Tea Party group in my district received a letter asking some pretty invasive questions, I believe, providing all their Facebook and Twitter information, for example, any of their advertising. They specifically mentioned a gentleman by the name of Justin Binnick Thomas, although it says Bink, B-I-N-K, it's actually B-I-N-I-K, I believe. It was just an ordinary citizen who didn't have any connection with that particular organization that received this inquiry from the IRS. And he also got no notification in that matter at all. They also got questions about providing a list of all the issues that were important to that organization, and they wanted to know what their position was regarding each issue. And I'm very concerned about the IRS's admitting targeting conservative groups and this overly invasive line of questioning and requests for information. It's really, I believe, more like harassment rather than an appropriate inquiry under 501c4 status inquiries. Now, the Attorney General announced back on May 14th that he had ordered an investigation by the FBI. Has the FBI begun that investigation now?
Yes.
Okay. And I assume that you can't go into the details of that because it's an ongoing investigation. Am I correct on that?
Correct.
Okay. Now, the IRS Commissioner, Stephen Mueller, initially blamed these actions, as I said, on 2 rogue employees way out there at the Cincinnati office. So how could we possibly know anything about that here in Washington, basically? And he acted like nobody here in this city knew anything about it or was connected in any way with it. Now, it's become pretty clear at this point that the IRS in Washington was involved in this. And I'd like to read a couple of things here relative to Elizabeth Hoffaker, who was one of the Cincinnati employees, and some of the things that she has indicated on the record. She said that the Tea Party cases, the Patriot cases, those types of organizations that were questioned by the IRS, that they were basically in a holding pattern, their applications. She indicated that they were basically in a black hole. She had been working on for 11 years at the IRS, and she said the way the IRS handled the Tea Party cases was unprecedented. So unprecedented, which I think is pretty significant. She said it was micromanaged to death by an IRS lawyer who worked in Washington. Again, no Washington connection, of course, but that's where this IRS lawyer was, here in Washington, D.C. And back in July 2010, the IRS developed what was called a BOLO list. Do you know what a BOLO list is?
No, sir.
Okay. Well, it stands for Be on the Lookout. BOLO, Be on the Lookout. And it instructed agents.
I knew BOLO in the law enforcement context. I didn't know whether you're using it in that context.
Yeah, it was used in that context to send half-acre applications from organizations involved with the Tea Party movement. And she told congressional investigators that she understood the purpose of the list was to target conservative and Republican groups. Other political groups did not get handled the same way, according to her. And a USA Today review of tax exemptions granted at the time showed dozens of liberal groups got exemptions while Tea Party groups were on hold. And subsequently, there was another BOLO criteria that came down from D.C. Talking about including groups whose issues include government spending, government debt and taxes, and if you're critical of the country or the direction that it's going or the way it's being run. And again, a lot of these things sat in limbo for 27 months. Will all these matters be investigated by the FBI no matter how high up they go?
I can't specifically assert that all will. To the extent that there is any indication of criminal misconduct, we will follow the leads and the evidence wherever it takes us.
Thank you.